All right, thank you so much. So I am so happy to be here with you guys today, talking about something that I truly love: trademarks, brand protection. Um, for the moment, I'm going to leave my camera on so you can see my lovely face. At some point, I'm going to switch it on just so that we have full concentration on the slides. So as you can see today, the title of our presentation is about being a brand boss. Okay. And I'm going to go into during the presentation a little bit more of what that means, or really it's going to unfold to you what that means. And I imagine that many of you on here are business owners or creatives or looking to be in those spaces. And how, being a brand boss is really something that you need to understand. It's something that you need to embody. It's a way to push and propel, your star forward. So as you already know, my name is Shaina Jones Magrone. I am the founder and managing attorney of Artisan Law, and we are going to get started. All right, so I want to give you guys just a brief overview of what this presentation is going to be today. And, I'm going to give you a little bit about me. We're going to do some IP overview. We're going to talk a little bit about brand building, go specifically into a trademark overview. We're going to talk about trademark licensing, which I love, and then a little bit about enforcement. I, of course, want to take any questions that you have, so please put them in the chat box. I will address them at the end, and I definitely want to make sure we get through all this material. So I want you to put your seatbelts on, enjoy the ride. We're going to have a good time. So a little bit more about Artisan Law. So Artisan Law was founded in 2018 by me. My firm specializes in helping business owners and creatives to build their vision and protect their legacy. I am the firm's managing attorney. I am a seasoned IP professional. I actually have a specialized degree in intellectual property, a master's of law degree, and I have 14 years of experience being an attorney. So overarching, this presentation is about an amazing and exciting area of law. I think trademarks are fascinating. They are one of the most important assets that a business owner and a creative can have. In conjunction with that, this presentation is also about a mindset shift of thinking of your creativity as your asset that should be invested in and protected. These are actual things that are meant to move you forward, and you should use them and protect them as such. So I just want to give a little disclaimer. So this presentation is only for informational and educational purposes, and it does not constitute legal advice. I am not your attorney until I am your attorney. Each person's legal situation is specific, and it requires individualized and private advice. Any use of trademarks in this presentation is done for informational purposes. Intellectual property drives a large segment of today's global economy. As a matter of fact, to get a little bit more specific, intellectual property constitutes the second largest portion of America's GDP. It is everywhere. It is in every sector. And if, you can, I don't know that you can go really more than 2 feet without seeing some form of IP. And it's something to be aware of what types there are, and how they interact in your life and what you can use them for. So valuable IP rights may exist in products and services that we see, hear, and use every day. So what is intellectual property? Let's get a little bit deeper into that. So intellectual property is a broad term for different types of categories of rights. These things are intangible. They're not actual physical property like real estate, but they're creations of the mind. And so there are 4 main types of IP. There are patents, which are used to protect useful innovations and discoveries like machines and processes. There are copyrights. Those are used to protect expressive works like art, music, dance, literature, and also computer software. There are trademarks, which are used to protect products, services, their company identifiers. Another word for that is a brand, a logo, and they are also used for package design. There are trade secrets. Now, trade secrets are commercially viable confidential information like business and financial plans, formulas, recipes, and customer information. So, a very famous trade secret would be the Coca-Cola formula. Okay. Now, let's talk a little bit about why IP matters. IP matters because it can be a company or a creative. And, anytime I use a company, I'm talking about a creative as well. So a company or a creative's most valuable business asset. Intellectual property allows someone to build their brand awareness and loyalty among customers. It can have an intrinsic value all on its own. It may be sold, licensed, or leveraged for profit because of that value. IP can drive innovation. It can enable the mark holder or the right holder to enter into new markets and to grow their market share. It establishes a protectable legal interest in goods and services that are sold, as well as the technology and the know-how used to produce them. They give the right holder a competitive advantage, and they create jobs. So oftentimes when we talk about intellectual property, you'll also hear a conversation about branding. And while I'm not a branding expert, branding does intersect particularly with trademarks. And so I want to talk a little bit about branding, how to understand it as a concept, so that you understand what its importance is to your trademark and how trademark is important to it. So as a general definition, branding is the process by which the name or the identity of a company, an enterprise, or an organization is communicated. How do you put yourself out into the market? What do you display to others about your company, your enterprise, your organization? Branding allows a company to differentiate its products and services from the competition by creating a bond with its customers. It aims to take the position in the marketplace and to create customer loyalty. So branding is meant to make you stand out from the crowd. It's meant to allow you to create a relationship with your audience, with your target customers. And that's oftentimes why branding has to be so specific, because you're looking to attract a certain type of individual. And so you're appealing to when you're positioning yourself around the things that will be important to them. So it also reflects in general a prestigious image in order to attract more customers. You want it to be professional. You want it to be something that your target audience is looking for and will be attracted to. So how are brands built? Now, this is a general overview of what happens when you're building a brand. You're looking for something to be different, right? To have distinctiveness, differentiation. And you want a brand that is also personally appropriate to your target audience. Is it relevant to your audience? So differentiating yourself in the marketplace, as well as being relevant to your target audience, allows you to create brand strength. And as you build on that brand strength, you gain in esteem. Your esteem deals with how well regarded is your brand in the marketplace. And then you're dealing with an intimate understanding as well as awareness of the brand, your knowledge of the brand in the marketplace. So your brand knowledge or knowledge of your brand in the marketplace combined with the esteem of your brand deals with your brand stature. So the best brands are going to have significant brand strength, and they're also going to have a significant amount of brand stature. And of course, they build upon the other. So successful branding will catch a consumer's curiosity. Now, developing a brand is part of a strategic business plan. That's one of the things that when you're setting out to create a business, you're really going to want to take some time to think about. You're going to want to target what customers care about, articulate those values and those qualities relevant to them so that you create a brand image that's relevant to them. Even in your personal branding, you're picking out the characteristics and things about yourself that are going to appeal to the type of audience that you're looking to attract. You're going to want to emphasize features that are important to consumers and differentiate yourself from competitors. You're going to want to have the ability to create something that you can sell, right? You're oftentimes creating a brand in order to generate revenue. And you're going to want to keep the brand and your ability around your brand to be flexible, possibly to create various versions of your branding. And you're going to want to look at and revamp your branding over the course of time. So you'll see the image on the left, you'll see brand at the top. And I really think of brand as kind of an overarching concept that has various subsets underneath, right? Your marketing, your value, your trust, your identity, your design, your logo, okay? So brand is that overarching concept that builds in other specific parts of that image that all go to create a cohesive picture. And so now in thinking about brand as that overarching concept, I want to talk about what a trademark is again and really kind of remix it, because trademark really is a way of communicating your brand. It's a part of that brand creation. It's not the only part, but it is a significant part. And a brand name is kind of like a calling card that promotes the image of a company and its range of goods and services. It's that thing that should be immediately identifiable to your audience to say, when my product and my service is marked with this brand, you know it's coming from me. You know what the quality is. You know who the originator is. Okay. A brand name is also, in a little bit more of a legal wording, is a sign distinguishing goods and services produced or sold by one enterprise from other enterprises. So a trademark may be made of any distinctive words, letters, numerals, pictures, shapes, colors, logo types, or labels. And you're going to see on the right-hand side an image of some very famous brand names. I'm sure that everyone here recognizes each one of these brand names and understands what the types of goods or services are that they signify. These are famous marks. We're going to talk a little bit about famous marks in a moment. Before that, I want to talk with you about some less traditional forms of trademarks. So there are single color marks, such as that Louis Vuitton Red that you see on the shoes, the red bottoms. Everyone knows what that color is, and it is trademarked. There are also three-dimensional designs, such as shapes of products or packaging. And one famous three-dimensional design is the Rubik's Cube. There are also audible sounds that may be trademarked. So I'm going to play this one for you, and I bet you'll immediately recognize what it is. Okay. Hopefully you all heard that. That was the NBC chime, right? The peacock logo. And then there are also olfactory signs, such as smells. And this was something new. This was something I learned. The smell of Play-Doh is trademarked. I mean, I know when I smell Play-Doh, it's immediately clear to me what it is. I know what that smell is, even if I don't see it. So, I mean, good use of the trademark office on their part. So now that I've talked with you in general about what a trademark is on a broad level and what some of the less traditional types are, I really want to delve into really the main categories. So trademark is an overarching term itself. When you talk about a trademark, people may be talking about an actual trademark, which is meant to distinguish goods, right? You may be talking about a service mark, which is used to distinguish services. And just going back to trademarks, you'll see that Google, I listed the Google trademark there. It is the actual most valuable mark in commerce today. You'll have service marks to distinguish services. And I didn't put any there, but my mark is a service mark, right? I'm in the business of legal services. You have collective marks, which are used to distinguish goods and services by members of an association or used by those members to indicate membership in that group. So AAA, for example, I know my AAA card is very valuable to me. You never know when you might have a problem on the road. So AAA is an example of a collective mark. There are certification marks. And certification marks go to illustrate or indicate that a particular good meets certain standards. So for example, USDA organic, when it's stamped on a food product, indicates that the cultivation of that product has been made according to certain standards, allowing it to be labeled as USDA organic. Energy Star is another one. One that I didn't put here, but it's kind of like a certain certification mark, is a geographic mark. So a geographic mark will indicate that a product comes from a certain region, and coming from that certain region, it has met certain standards. So for example, champagne is a geographic indicator. It's a geographic mark. It indicates that sparkling wine has come out of the Champagne region of France. And there are other types of sparkling wine, Cava, for example, coming out of Spain, but only those sparkling wines coming out of that part of France are allowed to be called champagne. And then there are famous marks. So famous marks are defined as widely recognized marks by the general consuming US public. Now, pretty much all of the marks that we've seen in this slide presentation so far are famous marks. I listed another one here, American Express. And famous marks will benefit from stronger protection in the US. I'm not going to go specifically into what those protections are, but just know that once a mark reaches that level, there's even greater protection around that mark. So now let's talk about the function of a trademark. A trademark is going to allow the mark holder to indicate that their mark is valid in a particular territory. And when I say territory, we're generally talking about a country. We're talking about federally registered USPTO marks, right? So a territory. And it is expressing itself as having a specific function, being related to a specific originator and for a specific good or service in the marketplace. It ensures that consumers are able to identify where a good or service comes from. And it also allows the mark holder to have the ability to license that mark through various types of licensing or franchising and receive benefit. That's one of the main ways you can receive benefit from the goodwill and the value of your mark. So let's talk about the value of a trademark. And there are a lot of values. It can be used as a marketing tool. It can be used as a source of revenue through licensing, which we just discussed. It can be a crucial component of franchising agreements. It can be useful for obtaining banks or third-party finance. And it's also a valuable business asset. So as I said earlier in the presentation, a trademark will have intrinsic value. As you've used your mark in the marketplace, and you have built up goodwill, which means um, positive benefit from the consuming public, positive knowledge, positive stature from the consuming public. That brand is going to gain an actual physical monetary value, and that can be used to leverage financing. The protection of your trademark is also going to be one of the most important things that third-party financiers are going to look at, you know, because if you are looking to invest in someone's brand and they haven't actually protected the brand, what are you investing in? Nothing. You're going to want to make sure that your brands are properly registered and properly protected. It's one of those due diligence things. Due diligence is a term for the type of investigation and discovery that may be used in a funding process, a merger and acquisition process, to determine that each party has their ducks in a row, has their house in order. And trademark is a significant part of that. Like I said, it's also a valuable business asset in each of these functions. So I want you to understand that trademark registration equals access. Now, there are a lot of people in the marketplace who never register their trademark for any variety of reasons. I want to talk with you about the significant benefits of federally registering your mark. And federal registration in the United States means registering your mark with the United States Patent and Trademark Office, also known as the USPTO. So registration provides you with exclusive rights to prevent others from marketing products or services under the same mark or a confusingly similar mark. Trademark registration can secure investment from banks and other third-party sources in your marketing or expansion efforts. It can promote customer loyalty, promote your brand reputation, and the image of your company. When people see the registered R symbol, which is the indicator that your brand in the US has been federally registered, and I'll talk a little bit more about that later, it indicates to people that you take your brand seriously and they should take your brand seriously. It also provides coverage in relevant markets where the business operates. So, of course, federally registering your mark in the United States is going to provide coverage in the US market. And it also will provide a springboard for when you get to the point where you're looking for international registration and protection. Registered marks also permit the licensing or the basis for franchising agreements. Like I said, going back into that due diligence situation. When someone is looking to license your mark or franchise your know-how, they're really using that brand to show that they're giving the same quality of product or service that you would be giving. And that quality or service is indicated by that mark. And the registration of that mark indicates that there's actually something there for them to use in order to delineate or demonstrate that brand protection is available. So let's talk about some practical aspects when it comes to having a mark or protecting a mark. Now, you can create your own mark, or you can buy someone else's trademark, not just license it. You can buy it outright. And you're going to want to do that after searching to find out that there are no similarly registered ones in order to avoid claims from other mark holders or refusals from the USPTO or opposition from those mark holders. You're going to want to protect your mark through a national or regional office. So in the United States, we have a national office, the USPTO. In a little bit, I'm going to talk with you about some international aspects, and there are certain regions that have regional ways of protection, regional offices. And then when you get to that level, when you've grown your brand to a certain extent, you may want to extend your mark to the world. And the main way to have international trademark protection is through the WIPO, which is the World Intellectual Property Office, the Madrid protocol system, the Madrid system and the protocol system. So you're going to also want to use and maintain your trademarks. So trademark registration is an ongoing responsibility. You've got to take care of it. You have to use it. You have to pay the appropriate fees in order to renew it. You have to respond to any requests or actions that you may get from the USPTO. And when you want to extend protection into different territories, you need to follow the protocols and the rules for receiving trademark in other locations. And of course, you're going to want to enforce your trademark. So you're going to want to make sure that you're monitoring to see whether or not someone is infringing on your mark. And if they are, you're going to want to enforce your rights. And then as the time comes, as you build, you want to innovate. You want to build. You want to keep offering something new, a new product. If you have a service, you're going to want to offer a new service experience for your clients. You must innovate or die. And a brand that is an amazing example of that is Kodak. Kodak was the thing to have in the 80s. It was an immediately viable and developed photograph. And it remained number one because it had an amazing R&D office, research and development office, that always made sure that it was creating a better version, new cameras, making the images crisper. And at some point in time, the heads of Kodak changed. Research and development was no longer a priority. They sat on their laurels. And now Kodak is a nostalgia tool. You can still find them third hand. You can still use a Kodak, but it's not innovation. It's not the thing to have. It's the thing to harken back to, when you want to go back to your childhood, or if you weren't around when Kodak came on the market, to use something that maybe your parents used. Okay? So let's delve a little bit further into protecting trademark through USPTO registration. So here's a couple of critical things that I want you to keep in mind. When you're filing a trademark application, you must register your mark in all of the classes that you are actually using your mark in, or that you intend to use your mark in. And you're going to want to make some strategic decisions about that. Now, there are actually 45 classes of goods and services that you can choose from. 34 classes are specifically for goods, and 11 are for services. You can have marks that are goods only marks, service only marks, or goods and services marks. And that's why it takes some strategic decision making to determine what your mark is actually being used for, what you want to protect it for in the market, and then to go ahead and protect it for that. Now, a substantive examination may be required in order to avoid conflict with an existing or similar mark that's been previously registered. One of the main things that's necessary to have when you're going for trademark registration is to undergo a substantive trademark search by a reputable trademark professional, reputable attorney. A trademark search is not simply typing your mark into the USPTO database and seeing what comes up. That's not all of it. Failure to do that can run you into some problems. You may face third-party opposition. You may have built your entire brand on this mark, and then you find out in the registration process that someone's already using it. You can't use it, and then everything that you've built is now not viable. You've got to go back to the drawing board. That's a significant waste of time and money and your creativity. All right? So once it's identified that there are no grounds for refusal, your certificate will be issued by the USPTO. And that registration certificate will be valid for 10 years. You will have to refile at the end of every 10 years. in order to indicate that you are still using your mark in commerce. Remember, trademark is a use it or lose it type of thing. You have to continue to show that you were using it in the marketplace for what you claimed you're going to be using it for. Now, in the first 10 years of registration, there's also what's called a 5 and 6 year period. And that 5 and 6 year period is when you must demonstrate to the USPTO that you've actually done what you said you're going to do. You have to present some evidence that you are actually using the mark in marketplace in the classes in which you register. After that, it falls to the 10 years and then every 10 years after that. Your registration can be renewed indefinitely, but it may be canceled if it is not used actively for certain periods of time as stated in trademark law. And I also wanted to say this. Not only can the trademark be used indefinitely by you, trademarks are legacy assets. They are estate planning assets. These are things that can be passed down to your children, whether you maintain it in a company or you maintain it personally, and they have value. You're going to want to make sure that they're not only protected from the USPTO, through the USPTO, and that they're used properly with your company. You're also going to want to make sure that you make estate planning provisions for how your marks, for how your brands are going to be used when you're no longer here, and who they can be used by. Okay, I'm sure you all can call to mind some, immediately some immediate cases, such as Prince's estate, Aretha Franklin's estate, that didn't have, estate planning in place, and there are fights over how, their creative works can be used. We're not specifically talking about trademark, we're talking about copyright for them mostly, right? Even though, Prince had the symbol. But the point is that all of your IP can be protected for generations, well, with the exception of patent, but we won't get into that. But they can be protected for generations, and you're going to want to make some estate planning provisions for them. So there are some other things to keep in mind when you're registering your mark. It takes time to register a trademark. It takes time to go through the USPTO examining process, okay? It can generally take somewhere between 9 to 16 months to go through the entire process, depending upon how backed up the USPTO office is. But regardless of how long it takes, it's worth it. It's worth the investment not only to protect your mark, but to invest in a skilled attorney to help you make sure that it's done right, and so that you can avoid significant substantive questions from the USPTO that may delay your ability to register or perhaps cause your registration to be refused. It's necessary to have a trademark search as one of the preemptive things to do to ensure that your mark can be registered or has a high likelihood of registration, because you're seeing that there are no conflicting marks in the marketplace. You're going to want to know about the appropriate use of the registered R, as well as the trademark and TM or SM symbols. The registered trademark symbol may only be used when you have a mark that has been registered and approved by the USPTO. That is the only instance in which you can use the registered R. The TM symbol indicates that you intend to go after federal trademark protection. The SM for a service mark indicates that you're looking to go after federal protection for your service mark. So use the TM if you're dealing with a product-based business, an SM for a service-based business. And if you have a mark that is a hybrid, both a product and the service, use the TM, because trademark is the overall catch-all term. You're going to want to think about protecting your trademark at home and abroad. This is an evolving strategy for your business, for your brand. And of course, you're going to want to keep in mind renewing your registration as well as uh, infringement protection and infringement monitoring. I want to talk briefly about the Madrid system for the international registration of marks. So the Madrid system was established a long time ago, and it was adopted by over 70 countries to ensure that if you register a mark through this system, your mark will have protection in 70 countries at once. It's an amazing system. It is so streamlined. Both the USPTO and the international systems are some of the most amazing governmental systems and entities around. The USPTO is consistently recognized as one of the best places to work in the federal government, as well as one of the most streamlined places in order to get something done. The WIPO system is revolutionary. It is amazing to be able to use that system and do so much at one time. Now, in conjunction with protection at home and abroad, I told you a little bit about the national route, right? So each country, you can seek protection in each country. Our national route is the USPTO. Each country will have their own particular national route. There's also regional routes for some areas. The United States doesn't really have a regional route, but some places will, such as the African Regional Industrial Property Office, the Benelux Trademark Office, the Office for Harmonization of the Internal Market of the EU, as well as the Organisation Africaine de la Propriété Intellectuelle, okay? So those are some regional offices where marks that are registered through those routes will have protection in various regions of the world. And then, of course, we talked about the international route, which will cover protection in over 70 countries. Now, if you're looking for international protection for your mark, you first must start with USPTO protection, and then you move on to the Madrid Protocol, if that fits with your brand strategy, your marketing strategy. I alluded to this and talked about this a little bit earlier. You must actively use your mark in order to maintain protection and to receive protection. Or you at least, in order to receive protection, must indicate that you're going to use that mark, and then at some point in the future, show it, right? There's two main types of trademark registration applications: an in-use application and intent to use application. Either one, you're gonna have to show that you're actually using the mark. So you're gonna need to actually offer your goods and services in commerce, in interstate commerce, crossing state lines. You're going to want to affix that brand, affix that mark to the goods or their packaging. If you're importing or exporting, you're going to want to import or export those goods under that mark. And you're going to want to use it in advertising or other forms of marketing materials. So briefly, using a trademark in advertising. I've worked with many a client, and they didn't necessarily start out with me, but they came to me later, where they registered a mark in one thing and then they started to use something completely different from what they registered, right? You need to use your mark as you register it. Whether it's a word mark, meaning you're only registering the words, or it's a design mark, which is also known as a logo. You need to use it how you register it. You're going to want to protect it from becoming generic. So some of the ways that you do that is setting it apart from surrounding text. If you have a design mark, you're going to want to use the specific font and size that you register it with, whatever the placement is, however the design is done, as well as your colors. You're going to want to use it as an adjective and not as a noun or a verb. It is not a plural or a possessive or abbreviated form. You use it how you register it. And you're going to want to put the world on notice by using the registered R. You want to monitor when others use the mark. You want to review your portfolio of trademarks as you build. And you want to have a mark that you periodically review to enable it to evolve. Let me talk to you briefly about some very famous evolving marks. Nike is a very famous evolving mark. If you look back in the history, you will see where it started is not where it is now. Most recently, it is the swoosh mark. And that is for the most part all it uses. It doesn't all the company uses. They don't even really use Nike so much anymore. They use the swoosh. The swoosh is so incredibly famous. Another mark is Dunkin'. Dunkin' used to be Dunkin' Donuts. Now it's Dunkin'. Both of these marks have evolved over time to propagate the new image that they're looking to present to the audience, but really flowing in line with a comprehensive level of evolvement or evolving and development. So using a trademark on the internet. Now, for the most part, if you're doing business, you're not going to get away without using a trademark on the internet. And why would you, right? The internet drives commerce. It is the place that you want to be. It allows you to sell your brand anywhere across the world, assuming, of course, you comply with various rules and regulations of selling your goods and services abroad. But assuming you do that, the internet is that conduit to let you do that. So there may be some extra steps that you need to take in order to secure your rights on the internet. You're going to want to be on notice of any conflict between your trademark and domain names, your internet address and other internet addresses, other internet addresses. And that conflict can be known as, or is known as, cyber squatting. Cyber squatting essentially means that someone has registered a domain name that comprises a mark just for the purpose of sitting on it and generally ransoming it for use. I'm a little tongue-tied today. Using it for ransom in order to have someone pay for the use of that mark. That's cyber squatting. You're not allowed to do that. Now, there is an international process in order to secure your domain name if cyber squatting has occurred. But you got to find it, which you generally may find because you're going to be looking to, register your domain name and you can't find it. And then you have to go through the WIPO process in order to secure your domain name. Now, when I worked at IBM was one of the places that I worked before I started my firm. That was one of the main things I did. I filed, they're called UDPR complaints. I filed those routinely for IBM, people that were infringing on IBM brands with the domain name or using the IBM mark on the domain name. So I filed those routinely. It can be a long process and it can also be an expensive process. And I'm a practitioner that thoroughly believes that it is better to do the strategic preemptive work up front to lay out the time and the investment in order to do it right than it is to have to lay out the time and investment to deal with the crisis. And when I say doing it right, I mean creating a strong trademark. And there are ways to do that. So you want to create a strong mark. You want to protect that strong mark. You want to use that strong mark. And you want to monitor for infringement of the mark. So you want to do it right up front as opposed to having to deal with things on the back end. And dealing with things on the back end can lead to, lawsuits, arbitrations, and I'm going to talk a little bit about enforcement later. But those things are significantly more expensive than the upfront investment of protecting your mark from the beginning. I'm going to talk a little bit about trademark licensing. And this is really using your mark as a business asset. So in trademark licensing, a mark owner, the licensor, grants permission to another, that's the licensee, to use that trademark on terms that they both agree on. This is a means of quality control. That's really the heart and the essence of trademark licensing. It allows the licensor to retain control over how their mark is used and to ensure that whatever is produced by the licensee adheres to the quality and standards that they've established in the marketplace already. Some examples of trademark licensing include franchising, which really is licensing your know-how in order to do something, and the brand that goes behind it. So you're using a mark to indicate that you are producing a good or a service in the same specific way as the originator. McDonald's is an exceptionally famous franchisor. Franchisees from McDonald's actually have to go to school for many a month to understand how to do it the McDonald's way, and they must continue to do it that way. And they're licensing those processes and procedures as well as the trademarks. Merchandising. I'm sure many of you know this, but some of you may not. A lot of the amazing luxury brands that we see on the market, are not necessarily produced by their main house. Louis Vuitton, Gucci, etc. They are licensing their marks to other third-party manufacturers, merchandisers, to produce their goods and services in line with how they would produce them. You can use trademarking as a brand extension. Say you have a mark that does, and your mark is for one type of good or service, and you're looking to move into a new type. You lend your mark to someone who produces that thing very well in order to extend your brand. And of course, you can have co-branding. You work with someone else to produce a particular thing under your brand name. You both do it all together according to the agreement that you have set up. You're going to want to enter into trademark agreements because they're an additional revenue stream. They allow you to monetize your IP. You can benefit from someone else's manufacturing, distributing, or sales capacity. You don't have to be a one-stop shop. You don't have to know how to do it all. You work with others who have a specialty in that particular thing. It can allow you to expand into other territories where you may not necessarily have the assets or ability into which you to expand into. And of course, it allows for product or service expansion. So enforcing trademarks. So it's the responsibility of the trademark owner to identify infringement and decide upon those measures. It's the trademark owner's responsibility to, engage in a service and engage with a professional that does trademark monitoring so you know what goes on with your mark. No one's generally going to come and knock down your door to tell you that someone's infringing upon your mark. Some of the ways that you may deal with enforcing against infringement are cease and desist letters to alleged infringers, search and seizure orders to people who may be housing infringing services. So, for example, Louis Vuitton or Coach purses. I'm from New York, very famous, raised in New York in Chinatown, of various owners on Chinatown having infringing purses, belts, so on and so forth. And, federal police will go with search and seizure orders and just scoop up those infringing products. If you're, doing international work, if you're having products imported or exported, there may be some cooperation with customs authorities to prevent counterfeit of trademark goods. There may be arbitration or mediation. If there is a level of infringement and there's a need to preserve a business relationship, maybe you've engaged in a licensing with a third party and something's going wrong, so you engage in arbitration or mediation to settle the dispute. And then, of course, there is a lawsuit, litigation. Okay? So we have come to the end and to the question and answer part. I hope that you have received an exceptional amount of knowledge. This is something that my sister said to me often, my sister who helped to raise me. Knowledge is power. I hope that you have received an exceptional amount of knowledge from this presentation, and it helps you to build your brand and to protect your brand. I want to thank you for your time and attention. Again, my name is Shaina Jones Magrone, the founder and managing attorney of Artisan Law. And you can contact me in the ways below. All right.
That was amazing. I thank you so much for putting all of that together. That looked like that was so much helpful information. I almost feel like you could have created your own Jeopardy with all that information in there. So thank you so much for the time and effort that you put into there. The thing that I took away, I had never heard of the Madrid protocol, was it, or the procedure?
Yeah, the Madrid protocol.
Yeah, that's really interesting and helpful for, any startups or anybody that has, again, any IP that they're putting together to have maybe more of a efficient way to, protect their IP. So there's like so many more helpful nuggets in there too, but I want to open the floor to any questions that attendees have. And again, don't hesitate to ask any questions. There are no wrong questions to ask Shaina.
Yeah, absolutely. So I told you guys to hold on to your seats. Many of these things that we talked about could be a presentation in and of themselves, but I wanted to give you an overview. I want to answer any questions that you have. So please feel free to just pour them on. And of course, if you can't think of it now and you have a thought later, you've got my info.
Lee is asking, can we get oh yes, so Lee, we will make this presentation available. So that's why we did the recording. So that's no problem. That'll be shared with attendees. And then if anybody is a Finding Fearless community member, then you'll be able to access in your portal as well. I thought the timing and, setting realistic expectations on that was really helpful. Also, like the value in doing it, even though it may take 9 to 16 months, that was really helpful. Is there anything that, Carrie, Lee, Michael, Rachel, Shannon, or Tasha that you found as a great takeaway from today? Feel free to leave that in the chat. So Michael is asking, can you receive a trademark without a formalized business?
Michael, that's a great question. Absolutely. So your trademark and your business are two distinct things. Something that many people tend to believe is that when you register your business name, you register the trademark. That is not true. They are distinct things, and your business name may not necessarily be your trademark. So they are different routes. When you are registering a business, you are doing a state registration according to whatever those state rules are. When you are registering your trademark, you are registering a brand name, which may be the same as your business name, may not be, but that is going to be with the USPTO. Now, I did not go into this. There is state protection for trademarks, okay? State protection is not the gold standard and is really not going to give you everything that you want and you need. That's a whole another topic for another discussion. Of course, I statewide register people's trademarks, but that's not what you're going for. You want gold standard USPTO protection.
Thank you for that. Tasha says, thank you, very informative. And Rachel is saying, I thought the presentation was excellent, not too legal, but enough to be informative.
Yeah. Awesome. I'm happy about that because, we lawyers can legal you guys to death. So I tried not to do that.
Tasha is asking, can you talk a little bit more about copyright and how it applies here?
Yeah, I absolutely can. So copyright is another form of intellectual property protection. It is distinct from trademark. So at the beginning, I talked about the four major forms. Those are patent, which is really used for invention, copyright, which is used for creative work. So you're going to think books, music, software. There are trademarks, which is for your brand protection and your logos, and trade secrets, which are for specialized knowledge that you're going to want to keep secret from the general public. So I did not go into this either, but I'm going to say this. There are times when the various forms of IP may intersect. There may be a possibility of protecting a certain type of work for different types of trademark, right? That's often going to be a strategic decision. But for the most part, you're really going to protect the thing in one particular category for one particular thing. All right. So when you ask how does copyright apply here, copyright is a way of protecting certain types of creative works. It is also something that can be licensed and be monetized. It is not the main subject of this presentation.
All right, so we have this final question from Rachel, and then I would love for you to share your contact information one more time after that. Rachel's
Absolutely.
asking, if an individual owns a patent or trademark or copyright, does it automatically pass into their estate when they die?
Yeah, that's a great question, Rachel. So, that's a great question, and the the answer is going to be it depends. It depends on who owns it, right? So you may own your mark in your own name. There are going to be many instances where you should not own your mark in your own name. If your mark is associated with your business, gold standard is going to be for the business to hold it because it's a business asset. And then when we're talking about your estate, yes, it should pass into your estate. It should. There are various things that may complicate that. So that's a really long and a really complicated question, right? But it should pass into your estate. There are certain time frames on intellectual property and the use of it. Copyright has certain times when it runs out. Patent runs out. I already told you trademark has to be renewed. And then you have to look at who has actual claims on it. So this is why you want to do this up front and have all of this worked out.
Rachel, it's no worries. Rachel saying, sorry, I figured it was more complicated than you can answer here, but that is a great question. Maybe that's a great
it's an amazing question. Yeah.
So where can people find you and how can they connect with you? Yeah.
So absolutely. I'll put my contact information in the box and I'm going to give it to you here. So of course, my name is Shaina Jones Magrone. My firm is Artisan Law. And I can be reached. My website is artisanlawfirm.com, artisan, ARTISAN. The main email to my firm is info@artisanlawfirm.com. I am on all the social media and LinkedIn, Artisan Law Firm on Instagram, Artisan Law on basically everything else. And I am on LinkedIn, of course, through my own name as well as my business page. So let me just put my contact information in, and I look forward to hearing from any of you that may want to chat with me further. Oh, and of course, not like anyone uses the phone anymore, but 212-548-4874.
Oh, got a 212 area code. Okay.
I sure do.
I see you. Okay. Thank you so much, Shaina. Thank you so much to everybody that attended and is watching. And again, you can reach Shaina where she is sharing that information. And thanks again. I hope you all have a great day and see you the next time we have a complimentary webinar. Take care.